Hey, everybody, and welcome back to the Legal Weekly Wine. We are at the end of season 2, having slogged through the Supreme Court decisions that have been issued in the summer of 2023. And today we are joined again by our wonderful guest, the Dean of the Honors College of Middle Tennessee State University, Dr. John Weil. I'm Virginia Tehrani, and we are both here to talk with you about the week's hottest legal topics. Welcome back, Dr. Weil.
Good to be here.
Okay, and so we have so much to say about Dr. Weil.
What was this about slogging through the Supreme Court? That was not how I interpreted it.
We had such a lovely time.
Okay, that's so much better.
Talked so many more episodes about each and every one.
Yes, okay, very good.
I think it really referred to the number of pages that we had to get
through. We did
through.
have to read a lot, yes.
The hundreds of pages and hundreds of pages of decisions by the Supreme Court, which had monumental things to say. But yes, I'll say it referred to that. But what we're going to do today is we have our amending process and Constitution expert with us, our expert on the Constitution and the amending process and constitutional law expert with us today. So we are going to spend the majority of today talking about the Equal Rights Amendment and what its background is, the background of the amending process, and where this stands today. So that's going to be the majority. But to start us off on an interesting and fun note, we're going to spend a little bit of time, since it's the weekly wine, talking about wine and Taco Tuesday. So anyway, I have with me, again, Dr. Weil. I really wish you would join us for some wine, but I understand your tasty beverage is this lovely water. All of you, it's happy hour on Friday. Grab a glass of wine or your favorite water or other beverage and sit back and enjoy. I've got specifically a Gewürztraminer, one of my favorite drinks. It is a wine. It is a white wine. This is called Turn. And I will drop a link to it in the description, but I got it at our little local wine store, finewine.com. And I also have that in the comments. So cheers.
Okay, hold on.
Yes, tell me.
Does this right. Go with Taco Tuesday or Taco Friday?
Is it right? I know we're in Friday, right? But we're talking about Taco Tuesday. So it is sort of Taco Tuesday in the sense that, certainly when we talk about tacos and Tuesdays, we talk about drinking. The two kind of go hand in hand. Of course, they go with tacos, but when you eat tacos, there's often a drink involved.
Usually not wine.
Not wine. It's usually some kind of beer, as I understand Taco Tuesdays and have used Taco Tuesdays myself. I love a Corona with them. People have their own choices, but if I do drink wine with Taco Tuesday, and people can say what they want to about whether it should be, you should use a red wine or a white wine with a taco. But I like cheese, lots of cheese with my tacos. So I default to a white, which goes very well most often with cheese. That's my preference. So that's why I have chosen a white for today, since I'm not drinking a Corona. We've only had one. Do you know we've only had one exception in the entirety of the Legal Weekly Wine from drinking wine? Do you remember which one it was? You were there.
Oh, yes, I do. And it goes along with today's case, Jack Daniels.
It does, yes.
So the Jack Daniels case that we discussed had to do with whether it was a trademark infringement to do a chewy, squeaky toy for dogs in the shape of and resembling the emblem of Jack Daniels.
The whiskey
bottle. The taco case is very similar. So Taco John's apparently had gotten a trademark for Taco Tuesdays, both in New Jersey. Pardon?
The term, right?
Yes, the phrase Taco Tuesday tried to trademark the term Taco Tuesdays, and Taco Bell was trying to sue to say that that wasn't an appropriate trademark. And
Because
what
they like
happened
to
this
refer to Taco Tuesdays.
right? And what happened this week is that the lawyers won again. Taco John said, we can't spend another $1 million on attorneys,
Yeah.
so we're going to drop the case.
Yeah.
But
Which
as
is
I
kinda
understand
sad.
it, pardon?
It's kind of sad. I mean,
Well-
it feels like the little guy can't get by.
Well, on the other hand, should you be able to trademark a term Taco Tuesdays? I have not read the case. I hate to say that, but I haven't. So I don't know the legal reasoning behind it.
It
But
seems like such the vernacular now. It's like, of course, it's a Taco Tuesday.
well, but is it because could it be because Taco John's started the term and went off with it, and then Taco Bell stole it from them? I just don't know. I don't know enough about the legal issue. But my understanding, by the way, is there's one state where Taco Bell still can't use it.
Oh,
You know the
I
state?
didn't know this. No.
Well, my understanding, and this was a quick read, so your viewers might want to check up on it, but that apparently New Jersey had itself somehow recognized this trademark within the state, and that's not right. I even knew states had the right to do.
I didn't know that either.
Well, again, we might, this is one where you might do a little research and put a little note at the end saying,
Yeah. Oh my goodness. I'll have to have what we may do is I'll swing you into one. I have a trademark attorney friend who maybe the three of us can get on one of these sessions and talk about the trademark law.
Okay.
That would be good.
You'd probably do just as well with your friend and yourself with the little bit that I know about trademark. I mean,
Oh my
I did
goodness.
the Jack Daniels case.
But between the Jack Daniels case and our Taco Tuesday, I can't exclude you.
Well, I won't feel too heartbroken if you decide to go elsewhere for expertise on this. But in
how
any
fun.
event,
Well, cheers and a happy hour and not Taco Tuesday to you. See, you're delayed. You were delayed in the cheers.
Cheers.
I still agree that white wine goes very well with cheese. The Gewürztraminer is lovely. It is dry, but not too dry. I don't like a really dry wine. So it really would go well with cheese. So I believe I'm correct. Grab your own bottle and try it with your taco next Tuesday or today for happy hour while you think about the next Taco Tuesday. So, all right. Well, thank you for doing that. So off we go, as I continue to say so, off we go to the Equal Rights Amendment. You're so well versed in amendments. In the amendments themselves, the ones that we have, the amending process, and what amendments have been proposed, how many have been proposed, what they've been, the status they have had, what they have been, met with. So your particular take on this is even to me better than anyone else, because that you've even done Rewriting the Constitution as one of your books. What are some of the other ones about the amending process specifically?
Well, I have a book called Conventional Wisdom, which deals with the unused mechanism in Article 5, the amending clause that would allow for 2/3 of the states to call a constitutional convention to propose amendments. I have, since you've given me the opportunity, I have
Please.
The 5th edition of my encyclopedia of constitutional amendments, proposed amendments, and amending issues will be out, I believe it's October. It's fairly soon. I've done all the proofs and we're just waiting to, sort of put the final polish on it. But the Equal Rights Amendment, what's fascinating about it, I mean, partly the history is fascinating, but it raises that there's quite a bit that we know about the amending process. We've adopted 27 amendments, although given that we've been in existence for over 200 years, that's a pretty low rate. It's one of the lowest rates of amendments of national constitutions in the world.
And especially when 10 of them were adopted all at once.
That's right. 10
and another 3 together.
Well, actually, yeah, the amendments tend to come in clumps. Your first 10 out of there are 12 proposed and 10 were adopted in what we now call the Bill of Rights. They were in response to anti-federalist criticisms that the new Constitution would create too powerful a government and we needed to list specific rights. And then after the civil, and then, there were 2 amendments adopted sort of between then and 1802, I believe it was. But then you go from then until 1865 without any amendments being adopted.
Right.
And then 3 are adopted very quick, 1865, 1868, 1870.
Which are known as the Civil Rights Amendments.
Well, so post Civil War amendments.
Civil War amendments.
Yeah, I mean, 13th Amendment prohibited slavery. And that, by the way, is back in the news, except in the cases of punishment for crime. And some people think that exception should be eliminated. 14th Amendment, probably the most, well, they're all important. If I were a slave, I think 13th Amendment might be more important, but
absolutely.
14th Amendment goes on then to guarantee that all persons shall have equal protection of the laws, due process of the laws, and privileges, immunities of U.S. citizens. And then the 15th Amendment, which worked more on paper than it did in practice, was designed to prevent discrimination on the basis of voting rights. And then you go another period from 1865 to, I believe, about 1913, and then you have 4 amendments adopted in relatively quick order from 1913 to 1920, the Progressive Era amendments. And then you have another amending a period, sort of late 60s, early 70s. But
and the ones you were just talking about, that included the women's right to vote as one of those amendments.
Right, the 19th Amendment was adopted in the Progressive Era, or sort of the end, actually, of the Progressive Era. It had been, it had actually been first, not proposed in Congress, but the idea of women's, let me back up. Women were actually allowed to vote at the time of shortly after the American Revolution, up to about 1800-ish in New Jersey. But they had to be women who were not living at home and weren't yet married. So it was the idea that neither their husbands nor their fathers could vote for them. And so, but when the Seneca Falls Convention met in New York in 1848, one of the ideas percolating there was the notion that women should be given the right to suffrage. And several people, drove to the convention when they heard this and took their daughters away and, said, I have no idea who this woman is. She,
oh my God.
It was really considered, for most people, considered to be a radical idea.
Which is interesting because that was proposed, you're saying 1848?
Well, it wasn't proposed in Congress, but one of the ideas in the platform there was that women should have an equal right to vote.
Which is incredible because that's even before African American slaves were even thought.
And actually, I want to go there because when the 14th Amendment is adopted, many prominent suffragists, and I've learned, by the way, that suffragette, which is often used, was intended at the time as sort of a derogatory term for women. So they preferred to call themselves suffragists. And they thought, many of them had fought very hard for abolition. And they thought that part of their reward should be that when African American men got the right to vote, that they should get the right to vote as well. And Frederick Douglass, who was, one of the engines behind the 15th Amendment, ultimately said, and he was a sympathizer with women's rights, but he said, as much as I understand that women don't have full equality, they have not been, as women, simply subjected to slavery in the same way that African Americans were. And that,
which is so true.
well, it was. I mean, but in any
African
event,
American women, when you want to add
right.
the two together, but
Well,
not
that's right.
white
That's
women.
right.
Mhm.
But in any event, they did not get included. Now, there were some who were hoping that the Equal Protection Clause of the 14th Amendment would work for women's voting. And there were actually a couple women who tried this out, showed up at the polling booth, were turned down and then sued.
Oh, wow.
And the court, and actually from a textual standpoint, the court might have, in the different ways to interpret the Constitution. If you just take the language, equal protection of the laws, and that'll lead us into the Equal Rights Amendment. Equal protection of the laws, although it was primarily adopted, we know, for freedmen, those who had been former slaves, the term itself seems to apply to all individuals, regardless of status or sex or previous condition of servitude. And so there were some women who were hoping that, and there's also a case about this time, by the way, that should interest you. And I believe it was Minor versus Happersett, and I wish I remembered the specific date, about the 1870s. Okay. But in any case, in that case, there was a woman who had gone to law school and sued to practice law. And the court said, no, the natural function of woman is to take care of the home, raise children. They don't have a right in the public square, if you will. And in favor of that, not in favor of that opinion, but textually, what worked in their favor was one of the provisions of the 14th Amendment had provided that states that denied the right to vote to men over the age of 21 could be factored in their representation in the House of Representatives. Oh. And so the fact that the 14th Amendment itself, now not Section 1, but I believe it was Section 3, but I'd have to look it up. But the fact that that amendment itself used gender language to, it would only apply if white men were deprived of the right to vote, or men were deprived of the right to vote, right, would seem to indicate that maybe women were not, in fact, protected by the language, even though the language itself was quite capacious.
Interesting. And that's different, though, because when we have the Constitution originally made, that didn't talk about women, but it did talk about slaves, about African-American men.
Well, not directly.
As the 3/4 or the 2/3?
3/5.
3/5. Neither number was right.
Right. The Constitution very purposely never used the word slave. It would always refer to such other persons.
Which is what we interpret, but
it meant slaves.
Right.
Lincoln said something to the effect that circumlocutions are the fig leaf behind which this part of the body politic hides.
Oh, that's a great quote.
Absolutely.
Use that more often.
Lincoln was good at using at knowing how to say the right word at the right time.
Wow. So we had that. Then we had the Civil War amendments. Then we had you're saying the Progressive Era
amendments.
And you actually have a tie on commemorating that, correct?
Well, actually, it's I have a book on the flag. But it's a book that has, I guess, what's supposed to be a suffragist there, waving the flag. And they did, particularly right in the during World War I, Woodrow Wilson, as I understand it, originally either opposed or was very tepid toward allowing women to vote. And Wilson, by the way, who in many ways was a progressive, was not a progressive when it came to the rights of African Americans. He resegregated the federal government at that time.
Oh.
But he did eventually support the Equal Rights Amendment, partly because the opposition of women to not getting the right to vote, he thought was hurting national unity at a time when, the United States had entered World War I.
Okay. So where are we after the progressive era? Now we have the actual civil rights movements. And what do we have around then?
Well, you have, you have the 2-term limit on the presidency. You have electoral votes for the District of Columbia. You have the elimination of the poll tax. You have the 25th Amendment, which provides for presidential disability. 26th Amendment provides for voting rights for 18 to 21-year-olds. And then the one that actually is the most relevant to today is you have the 27th Amendment, which was proposed back in 1789 and was adopted in 1992. And
how does that happen?
Well, it happens because the Constitution, and Article 5 is a part of the Constitution related to the amending process, does not specifically define when an amendment how long an amendment can be before it's ratified. So 2/3 of Congress propose, 3/4 of the states adopt. What is the time period between one and the other? Well, the Constitution doesn't say.
It's silent.
Now, it's silent on the matter. Now, what happened is beginning with the 16th Amendment, though I may be mistaken on this, but the amendment providing for the national income tax, which I'm sure we all know and love.
I haven't committed the number to memory, but I know about that income tax.
Okay. In any event, beginning with that, and apparently as sort of a poison pill, and I believe it was Warren G. Harding who did it, who was then a member of Congress. They tacked, although it may have been Aldridge of New York. And in any event, they tacked on a 7-year ratification limit, thinking that it would take longer than that, and then the amendment would die on its own accord. And I think I may have this backwards too. It may not have been the 16th. It may have been that they did that for the 19th. In any event, they tagged it on an amendment. And there's 2 court cases, which as a lawyer, I'm sure you will appreciate. One in 1921, there's a case, Dillon versus Gloss, in which the court says that amendments should reflect a contemporary consensus, which makes sense, right? There shouldn't be such a big time between proposal and ratification that you're not really sure that it represents the consensus of the people at the time it's adopted.
Right.
But 1939, there's another case, Coleman versus Miller, in which the Supreme Court says, yes, there's a contemporary consensus, but that's to be determined by the political branches. It's a political question for Congress to decide. And as a result, and so what happens in 1992?
Wow.
What happens in 1992 is a guy named Gregory Watson, who is a legislative aide and student at the time. Well, he was a student at the University of Texas who wrote a term paper for a political science class, and he got a C after suggesting that the amendment prohibiting Congress from giving itself a pay raise until after election, that amendment could still be ratified. That was proposed as one of the original 10. And he subsequently, by the way, they had a ceremony in which the professor retracted his grade and gave him an A after he spent $5,000 of his own money and called legislators all over the country to get them to adopt the 27th Amendment.
And they did.
And they did that. Well, they did. Now, there are some of us who suggest that the amendment is still a bit tainted. And as a result, courts don't seem to have enforced it quite according to the letter that, they have permitted so-called COLAs for members of Congress every year, even though there's not an intervening election between each one. But nonetheless, what the difference is this. So are we ready to go to the Equal Rights Amendment?
Please, no, thank you.
How many side paths can I take before I get there?
No, but this is good because it's an understanding of how we are even at this place, how, like you're saying, how the amending process works. You're the one who knows. And
some of it nobody knows, because we don't have definitive court decisions on them.
Mm-hmm.
And as you know, even if we had a court decision,
they're
court doesn't always
interpreted
abide by stare decisis.
Nor do they interpret it the same way.
That's right.
If they did, we wouldn't need the court. It would be so self-obvious.
So in 1972, let me look at my notes. Sure. 1972, well, go back to 1923, which would have been 3 years after the adoption of the 20th Amendment. Congress introduces an amendment which basically says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And it is continually reintroduced. If I remember, the Republican Party goes almost 50 years, every 4 years, putting in their platform that they favored the Equal Rights Amendment. Now they changed.
The Republican Party did.
The Republican Party, maybe the Democrats too, but I know the Republican Party did at the time. They changed their mind in about the time that this one is introduced in 1972, a little thereafter. But nonetheless, it's first proposed in Congress in 1923. They finally get 3/4 of both houses of Congress to agree to, 2/3 of both houses of Congress to agree to it in 1972. And prior to this time, as we've discussed, amendments had been introduced fairly systematically with a provision that says this amendment will not be valid unless it goes into effect in 7 years.
By the state.
Ratified by the states within 7 years. I'm not quite sure where they got that number from, but it would stand to reason that it would take more than a year or two. Some state legislatures only meet, at the time, I think some were meeting only every other year. And, some want to have an election prior to voting on an amendment. But in any event, so most amendments from this period, you will find this time limit in the amendment, which, as I understand it, and Walter Dellinger, former Attorney General, has a great article on this. I believe he's now passed away, but had a great article on this saying if it's in the text of the amendment, it's self-enforceable.
Okay.
Now, people looked at this and some of them said, well, this is sort of silly. We have a series of amendments, each one of which says the same, if not ratified within seven years, it doesn't become an amendment. This is sort of constitutional chaff. We don't need it in the Constitution. So when they introduced the 1972 amendment, they said, well, instead of putting it in the text of the amendment, where it'll clog up our Constitution, we'll simply put it in an authorizing resolution. We'll keep the time period the same, 7 years, but we're not going to put it in the text. And I don't think anybody I think it was almost purely an aesthetic decision.
Right. But they assumed that the timeline would apply.
Right. Right. The people, when it went to the states, it went accompanied by an authorizing resolution that said this won't be valid unless it's adopted in 7 years. So it's proposed in 1972. So tell me what happens the next year that throws a monkey wrench into this.
Oh my goodness, in 73. Oh, of course you're going to ask me. I
Okay,
don't
I'm
know.
sorry.
Maybe,
You're right.
maybe on as soon
It's
as you
since
say
been
it, I'm going to
overturned.
know.
It's since been overturned. So overturning the Dobbs decision.
Oh, it was Roe.
Yeah.
Okay, that was 73.
Yes. Okay.
Okay.
Well, and
Thank you.
and I say threw a wrench in it. That's not the only thing that's happening. This is about the same time. I believe Frontiero versus Richardson is 1972. One of the cases in which it was decided that a man and a woman both had equal rights to be executor to an estate. You wouldn't automatically assume the man over the woman. So the Supreme Court about this time is already beginning to use the Equal Protection Clause of the 14th Amendment to accomplish much of which people arguing for the Equal Rights Amendment were for.
Okay.
In other words, and there's not that much difference really in the wording.
Yeah, what is give us the wording of this Equal Rights Amendment?
Well, no, I think I did earlier, but that's right. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex.
Okay.
And, the 14th Amendment calls no state should deny to any person the equal protection of the laws.
So it just basically added that extra piece is
it's on the basis of sex. I mean, it's on account of sex. The language is similar to the 19th Amendment, but the 19th Amendment refers only to voting rights.
Okay.
Now, let me back up a little bit. One of the difficulties with the equal rights, why does it take? Okay, it takes from 1848 to 1920 to adopt the 19th Amendment, give women the right to vote. So what were the obstacles there? Well, a lot of it was just traditional ideas of the role of women, fear that women would become tainted by their association with the political process. And this was a man's world and that sort of thing. So what were the obstacles? Pardon?
My doorbell has rung. It's one of the risks of having my YouTube studio in the basement. Apologies. Go ahead.
Fair enough. Okay. So this takes us to what were the obstacles? Why did it take from 1923 to 1972 to adopt the Equal Rights Amendment? And I would say one of the primary obstacles, there are two or three. One is there were actually some advocates of women's rights who strongly opposed the Equal Rights Amendment because they had been working to put in special protections in the law for women. To the extent that women are not as physically capable maybe of working a 60-hour week as a man might be, particularly if they have to take care of a home as well.
The idea behind it.
Many of the early minimum wage, maximum hour legislation applied specifically to women.
Okay.
And so some were afraid that you might give up some rights. And then what happened in 1972, so the Equal Rights Amendment is finally adopted. It's very quickly ratified by 30 states or so in the first year or so. Okay. Things are going along well. And then you start getting Supreme Court decisions. And maybe you had a few before, but Supreme Court begins interpreting the 14th Amendment in a way that seems similar to what the Equal Rights Amendment would do. And then you get Roe versus Wade. And one of the things, so there was actually, when the Equal Rights Amendment was proposed, there was something called the Hayden Rider that originally was added. Well, when they get ready to vote on it, they would add this rider, which would basically say, but the amendment shall in no way undermine any rights that have already been given to women, special rights that have been given to women. Okay. And then the issue came up, 1972, we're getting toward the end of the Vietnam War, but we're still in a period of the draft. And one question that was never answered, probably purposely, was if you have a draft and you have an Equal Rights Amendment, does that mean that women could be equally drafted with men? And people had strong opinions on both sides of this, by the way.
Right.
Some said, that women, if women have full rights, then they have full responsibilities. And others said, well, that would just be too disruptive. It's too different from social norms to permit that to occur. So that was lingering out there. And then Roe versus Wade is decided, and people say, well, does the Equal Rights Amendment, would the Equal Rights Amendment mean that women have a complete right to an abortion?
Okay.
And Phyllis Schlafly, the Eagle Forum, very activist woman, who fought for traditional gender roles, fought as an activist for equal gender roles,
for her gender role,
which I love. But anyway, she comes along and says, does the Equal Rights Amendment mean that we're going to have all unisex bathrooms?
And that was in the 70s.
That was in the 70s. So, which is just so all these, and probably, most people said, well, of course not. You still have a right to privacy. Well, right to privacy, we know where that is now. That's not explicit in the Constitution. So she raised all kinds of fears that ultimately stymied. You need 38 states or 3/4 of the 50 to ratify. At 35 states, they couldn't get any more. So 7 years pass, 1979 comes up, and Congress says, let's give it another 3 years. This was highly contested. Remember, there's nothing in the Constitution that says how. Right. Okay, and then it's going to get even more.
That says how long it's supposed to stand out there.
And if it's in the text of the amendment is self-enforcing. This was in an authorizing resolution. So we extend for 3 years, still no cigar. So most people then said, okay, it's over. But now there are people who are saying that was never part of the amendment. If we can adopt an amendment the 27th, 203 years after it was proposed, why can't we adopt this?
Why not?
Now, and what has subsequently happened? Let me see if I have the states listed. Three states, Nevada, Arizona, and Virginia. I may be wrong about Arizona. Anyway, if you read my new encyclopedia edition,
we'll know. Everybody look.
No, I'm wrong. Okay, it's Nevada, Illinois, and Virginia.
Okay.
They add their ratification to the Equal Rights Amendment.
But
so
when?
They're now 38 states that have ratified.
But when did they do their ratification?
Well, they did it in the last couple years.
Okay.
Nevada 2017, Illinois 2018, Virginia 2020.
And how many do we need?
38. So we now have 38 states have ratified, but it gets more complicated. So not only did they not ratify within the 7 years or the 3 years, but a number of states have tried to rescind their ratification. Oh. They say, when we favored the Equal Rights Amendment, we thought it just meant, we didn't know that it can have all these other ramifications, so we're not for it. And the Constitution is silent on the issue of state rescission.
Oh my
now, we do know that there have been states who have voted against an amendment whose ratifications were subsequently counted after they took a new vote. But we've never had a definitive. Now, there's a U.S. District Court decision on the Equal Rights Amendment, which said you can rescind, but it was ruled moot after the 7-year and the 3-year deadlines passed. So, but there are some, and I get it. Some people say, after all these years, the very least we can do is have a constitution that gives women equal rights, recognizes that they have equal rights. And others say, and here's where it gets tricky. Others say we don't need it. It's already been done through the equal protection law. And then somewhat
Yeah.
contradictory, others say, and if we do adopt it, what's it going to mean now? Well, in the absence of the Dobbs decision, people are going to go to, or I'm sorry, in the presence of the Dobbs decision, people are going to go to this amendment and say women are not being treated equally if they don't have the same medical rights that men have.
Okay.
So that's where we are with it.
Wow.
Very controversial.
So is anyone yet suing over it? What's the
Well, there are
thought
some who
behind
are
it?
demanding, right? There's the person responsible, and it's changed about 3 times in U.S. history. It used to be Secretary of State. And I'm not sure. There's look at my encyclopedia. There are 3 of them. Now it's the National Archivist. So
Okay.
some are saying the National Archive, and he, by the way, did, if I remember, the National Archivist did certify the 27th Amendment, although Congress came back and then gave their approval to the certification. So some are saying that the head of the National Archives should ratify the amendment. The
Since
Trump
it's already
administration,
done.
well, Trump
Allegedly with the
administration,
38th.
pardon, well,
Allegedly with this 38 vote.
well, but he has not certified the amendment because that didn't occur within the 7 or the 3-year extension.
Okay.
And I'm sorry, I'm getting too excited here. I'm losing my train of thought.
No, this is fascinating.
But basically what happens is he's saying, I can't under these, it shouldn't be up to me in these circumstances. And so Congress is saying, well, we have some people in Congress are saying that we have the right to decide, so we should go ahead and vote for it.
Mhm.
Now, at the end of the Trump administration, the Justice Department handed down a ruling saying that in their judgment, it was too late to be clear, their position, as I understand it, and I think it would be my position, but for a somewhat different reason, would be you have every right to adopt the Equal Rights Amendment, but you got to start the process over, to make sure we have this contemporary consensus. But my understanding is that Biden administration has said, we don't go by that. We believe, in fact, that Congress can, in fact, ratify this amendment 30, however many years after it was proposed. So that's sort of where we are.
And we're just pending.
Right. And again, the question becomes, and here's what, this is really tricky. Would it make any difference? The way the Equal Protection Clause has been interpreted, most barriers, used to be for many in the 19th century, man almost always got custody of a child during a divorce dispute. That's no longer the case.
Right.
Property rights, I think, are, you'll know this better than I do, but, in most areas of the law that I know have been, in fact, pretty equalized between men and women. And we don't have a draft anymore. If we did, that could become a really big issue, but we honestly do not know, or at least I do not know, if the equal rights were in effect and we ever had a draft again, would it mean that women were equally subject? Now, they could be equally subject to the draft and not necessarily be equally subject to being in combat.
Sure.
For many
or
years,
exceptions might apply. There are so many different ways to apply it.
Right. But and then the other question is, there do seem to be some who are advocating the Equal Rights Amendment in the belief that that amendment would in fact protect abortion rights. And that issue, remember I said that one of the primary issue opposition to the Equal Rights Amendment was, would it diminish protections that women have? But there was this other element, is there some kind of hidden agenda?
Right.
Is it really an amendment allowing for an abortion in other terms? And I know that there were some prominent proponents of the Equal Rights Amendment who disfavored abortion. So it wasn't their intention, but as you know, it's not the private intentions of people who propose something. It's what does the language actually demand? And
Exactly.
I think you could make an argument probably either way for the equal. Now, there are a number of states, maybe even a majority now, that have their own equal rights amendment. But I'm, it's sort of a dilemma. Unless you think it would apply to abortion, it's hard to know immediately what effect the equal right adoption of the equal, 19th Amendment is adopted. We know what the effect is going to be.
Right.
Women who were excluded from voting, and by the way, some states had permitted voting, beginning with Wyoming.
It just required the country to allow women to vote.
That's right. No state now or nation would be able to deny it. We know the consequences of that amendment in a way that I don't know specifically if the Equal Rights Amendment would enhance the right to abortion or not. I could see how you can make an argument that it would. It's unique to women, and so it burdens them in a way that it doesn't burden others. But I don't know that the court could say, you could cite some of these people and say, well, they did not favor abortion. That's not what it meant. And I think, here's where liberals and conservatives might converge. The great fear that Phyllis Schlafly had, and she was also very good at knowing what issues would have emotional appeal.
Yeah. But
when you raise issues of privacy, these are things that they bother people. Yeah. And I'm about to lose my train of thought again. Right. So she was fearful that if you adopted the Equal Rights Amendment, the Supreme Court would use it to push equality in a direction that it had not previously been used. And in fact, if you remember, we talked about, I think it's the Bostock decision a time or two back, where, when the 1964 Civil Rights Act was adopted, it said there should be no discrimination on the basis of sex. And that has now been applied also to transgender. It's been applied to LGBT rights and the like.
Right. And that's where I want to follow back up with you, but go ahead. The question.
And so the question is, do you want to give language which is very broad to the Supreme Court to do with it what you want? And those who, the liberals who would typically favor the Equal Rights Amendment, it might give a little pause to say, hey, this is a court that just struck down Roe versus Wade. Maybe we don't want maybe we don't want to give them language that they can interpret in I don't know how you would exactly interpret this in a conservative direction, but, given the current court, and that's why I think part of the controversy of the Equal Rights Amendment is always, what exactly does it mean?
Yeah.
I mean, on its face, we know what it means, but does it mean, does it apply to the draft? Does it apply to abortion? Does it apply to the right to privacy? Does it extend, does gender mean male, female? Does it go to LGBT? Does it go to transgender rights, et cetera, et cetera?
Yeah. And is that, I guess my biggest question then is, are states rescinding because of this fear that it would include abortion, and or because of the fear that it would include sex as defined through the LGBTQ community?
I think the second. I think it's too late. I don't know that any. I think the rescissions have occurred long before Dobbs.
Okay.
Or the attempted rescissions. And by the way, the district court opinion, which declared that the deadline applied, also had said that states did have the right to rescind it. And by the way, one might argue you could make an argument that even if you don't think typically a state should be able to rescind, maybe it should be able to do so in a case where the authorizing resolution had said giving it 7 years and it hadn't been adopted during that time period.
Mhm. Wow. Well, this is interesting because it seems that it would be extremely hard in this time to get another amendment. There seems to be no greater time of division within Congress to actually
right.
meet that requirement needed to pass one. So I understand the idea of saying, oh, we've already got it, so
Right.
that they can pull something like this that gives more rights and a definition, whether vague or not, at least some definition within the Constitution to more liberal rights.
Right. And there are some, by the way, who think that the Equal Rights Amendment didn't go far enough. Some liberal proponents who say, you know, we need to be more explicit. Needs to be to greater depth to it. So pretty interesting.
So let me ask you one final question, though. I'm trying not to take all of the time with the Equal Rights Amendment, but it's so fascinating. And you're the one who wrote the book on this. Let's bypass Congress. How do we ratify it through the states if we go around Congress? There is a way to do this.
Right. Two-thirds of the states can ask Congress to call a constitutional convention to propose amendments. Now, I have a whole book on this, University of Georgia Press. But there are all kinds of questions surrounding it. The most interesting of which is, can the states call? And my answer is yes, but I'm far from, I don't know that I'm even in the majority of this. Can you call a limited constitutional convention? Can you call a convention that would simply discuss and propose an equal rights amendment or a balanced budget amendment or, a term limit?
Rather than including all possible amendments.
Right. And, even more complicated or as complicated is how would delegates be chosen? By whom would they be chosen? How would states be represented? And there are some, I'm not among them, who think very firmly that because the U.S. Constitution was adopted by a convention in which states are represented equally, this convention would have to be too. I think probably the fairest way would be to do something like the Electoral College, where each state got a number of delegates based on its total number of representatives and senators. But that's far from a unanimous view.
Has this form of amending the Constitution ever been used?
No. Well, let me add a qualification. There are two ways to ratify amendments. One is by 3/4 of the state legislatures, and the other is by special conventions called within each state. This is at congressional specification. The 21st Amendment, which overturned national prohibition, was adopted by state conventions. But the answer is, have we ever had an Article 5 constitutional convention? No, we've never had one.
To propose a new one.
Right. Now we've had a number of proposed laws that would seek beforehand to specify how such a convention would be conducted, how states would be represented and the like. None of them has ever been adopted, in part perhaps because you think about it, Congress sort of has an interest in keeping this game to themselves, right? In proposing their own amendments without somebody else coming in. So do they necessarily want to clarify a method that would effectively bypass Congress? Probably not.
Okay. All right. Thank you so much, Dr. Vial, for being on with us today, for telling us everything about the amending process, the Constitution, how this is working. And truly, it is one of the most fascinating topics that I have heard in a long time. And I thought, it's the Supreme Court decisions, but this seems like a topic so fueled for a Supreme Court decision. It is like we've talked about before, is this a case in controversy yet. And I don't think we've gotten there.
No. Yeah.
Okay. Well, thank you for being on with us today, as well as through our second season of the Legal Weekly Wine as our expert scholar in the field. And we hope that you will join us again in season 3.
Look forward to it.
All right. Thanks, everybody. Happy hour for this week in July. Stay as cool as possible through the rest of the summer and try to stay away from all the crazy smoke out there, which is not a part of the Legal Weekly Wine, but certainly a big topic for the summer. Take care, and we'll see you in season 3.